Section 13 violation, 1 lakh penalty on the company. We'll discuss an important ROC adjudication order where a company was penalized for acting beyond its object class. So many companies ignore this compliance and many professionals or directors assume it is a minor issue. But this case proves otherwise. In this case of Simran Agrovet Limited, ROC imposed a penalty under Section 13, Section 10, Section 450, and Section 454, and Section 446B. This is for relief for small company. So let us understand the complete legal position, facts, penalties, and what exactly happened in this case. What is the practical lesson? Section 10 of Companies Act 2013, binding effect of MOA. Section 10 provides that memorandum and articles bind the company and members. Company must act strictly within its objects. If company acts beyond objects, it becomes ultra wise. Here, in this case, alteration of memorandum talks about section. Here we can see section 13 of Companies Act. Alteration of memorandum. Section 13 governs change in the object class, requirement of special resolution and filing with the ROC. First, company has to alter MOA, then start new business. That is the key principle. But here the company did completely opposite. And we also talked about section 450, that is a residual penalty. This is general penalty section. It applies when no specific penalty provided elsewhere. Any provision of the act is violated. Penalty prescribed 10,000 is the initial penalty. 1,000 per day, continuing default, maximum 2 lakh. And on the company, and maximum 50,000 on officer in default. Same thing reproduced here. Section 454, adjudication of penalties. This section empowers ROC to issue show cause notice, provide hearing, pass adjudication order, and impose penalty. So ROC Gwalior acted as adjudicating officer. Section 446B, that is a lesser penalty for small companies, very important relief provision. If company is 1% company, small company, startup, then the penalty not more than 50% of normal penalty. 1% company, small company, startup. So here the facts is the company Simran Agrovet Limited. Here ROC Gwalior. Nature of default, ROC found that from 21st January 2022, the company started integrated poultry farming business. But MOA covered only poultry feed. ROC clearly held poultry feed does not specifically cover integrated poultry farming. So both are different. Therefore, the company acted beyond its object class. This is what exactly happened. Then, good point actually noted by ROC. Company later realized the mistake, passed a special resolution on 16th April 2025. 16th April 2025 and altered object class, new certificate issued by MCA. However, post facto correction does not erase fast default. So ROC followed due process. Suo motu application by the company because the company itself filed GNL1 and then Shokas notice issued, written submissions filed, e-hearing held, and then final order. So proper natural justice followed. So period of default ROC considered from 21st January 2022 when company started integrated poultry activity. Here is a very important for the promoters, directors, and the professionals. Inadvertent activity counts, even intent is irrelevant. Actual conduct matters. And also, in this case, ROC considered small company benefit. Examined section 2, subsection 85. So here the company qualifies small company. So 446B relief is applicable. Here you can see in this column maximum penalty, here penalize on the company instead of 2 lakh penalized with 1 lakh. And even for all the directors, each director 25, maximum penalty 50. But a small company benefit is given. Each director 25, 25, 25, 25, 4 directors, 25 each. Penalty has to be paid through director's personal account. Company cannot reimburse. If they wish, they can go to appeal before RD. Even a related activity can be violation. This is what you can see the difference. Poultry feed versus integrated poultry farming. ROC treated them as a different. So that is the reason draft objects carefully. Always alter MOA first. See the sequence: pass special resolution, file MGT 14, obtain new certificate, then start new business. Section 446B is a very powerful. Small companies, no penalty reduced by 50%, huge financial relief. So when does this ultra-wise risk arises? The situations are business diversification and new vertical launch, change in product line, group restructuring, startups pivoting a business model. So always review MOA before expansion. Hope you are clear. We have 2 channels, RR Corporates and RR Legal Talks. Please do subscribe, hit the bell icon so that you will not miss any of my latest videos. Thank you.